Welcome back to This Week in Immigration. I'm Jordan LaPier. On the program this week, the Flores fix, public charge regulations, and the latest on border apprehensions. Before we get started, please remember you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. And if you leave a review, it'll help more people find our show. You can also stream This Week in Immigration on our website at bipartisanpolicy.org/podcasts. And as always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. Here with me today are Theresa Cardinal-Brown, Director of Immigration and Cross-Border Policy, on Twitter at BPC_T Brown. Welcome back, Theresa.
Hey, Jordan.
And Chris Ramon, Senior Immigration Policy Analyst on Twitter at CRamonBPC. Hey, Chris.
Hey, Jordan. How's it going?
Good, thanks. All right, let's start here. Last week, the administration announced what they call the Flores fix, new regulations that would change the Flores settlement, which is the court settlement that says, among other things, that children in detention can't be held for more than, in immigration detention can't be held for more than 20 days. Theresa, walk us through these new regulations that the White House announced.
Sure. So this is a final regulation based on proposed rules that they had put out late last year. It is meant to supersede the settlement agreement in the Flores case, which sets out conditions for detention and or release of children. The fundamental issue for the administration is an extension of that agreement to families who are in detention with children that happened in 2015. The judge in the settlement said that the Flores settlement applies to children who are detained with their families and said that cannot be more than 20 days. Unaccompanied children, the limit is 72 hours, and that would remain unchanged. These regulations are meant to incorporate into regulation the requirements of the settlement agreement, supersede the agreement, and basically terminate that settlement. It would allow for an indefinite detention of families with children, by indefinite as meaning there is not a maximum length of stay. It would incorporate certain requirements for what those facilities might look like. But importantly, right now, under the settlement agreement, children are supposed to be only housed in facilities that are licensed by a state to care for children. There are no state licensure requirements or state licensure capability for detention of families, and so family detention centers can't meet this licensure. This regulation would allow the government to self-certify its standards for family detention. It would create some sort of independent entity to oversee this, but that entity is not been created yet.
What's the significance of these actions? Why now, and how quickly will they go into effect?
So this is something the administration has been asking for years, since the 2015 ruling that expanded it to families. The administration believes very strongly that the limitation on detention of families has encouraged families to come to the United States, particularly the Central American families, has precipitated this massive increase in the number of Central American families we've seen at the border, and that by allowing for longer detention of these families as their asylum cases are proceeding, it would in effect act as a deterrent and prevent or deter more families from coming.
I think the other thing to consider with the significance is that it not only has it been a priority, but it sort of fits into their broader border enforcement strategy of using different regulations in order to create a regime that sort of deters the arrival of migrants, particularly migrants from Central America. So we've, on this podcast, we've talked about Ramon in Mexico. We've talked about the so-called asylum bans. This is part of that strategy as well, to sort of set this up via regulation without relying on legislation.
Theresa, do you see this as part of a coordinated plan, or is this an isolated strategy?
Well, it's not a strategy. It's yet another in, as Chris said, a series of efforts the administration has put forward to try to find something that will work to reduce the migration to the U.S. Mexico border. And as Chris mentioned, they've been trying several other strategies, some of which have been stopped by the courts, some of which have been in place. This is yet another in that series. And in fact, it kind of contradicts some of the other things they've been trying to do. So, for example, this is saying that families who arrive at the border and apply for asylum can be detained in Immigration and Customs Enforcement detention while their cases are pending. Well, the migrant protection protocols, the so-called Remain in Mexico policy, was put in place to say that if you apply for asylum, you will wait out that time in Mexico. So on one hand, they're saying we want to be able to detain families here. On the other hand, they're saying, but we want to send them back to Mexico. So clearly those are at odds. You either detain them in the United States or you send them back to Mexico, not both. What are you trying to do? So that indicates to me that there's not a coherent strategy. This is an effort to put everything out there they possibly can to see, one, what will survive the courts, and two, what might be effective at reducing or slowing the flow. And so far, not really anything that they've tried has been successful at that latter.
A lot of this is underscored by the fact that they scored that victory with the travel ban, the third iteration of the travel ban with the Supreme Court. And so I think a lot of the thinking is they're thinking, okay, let's get something across the finish line, anything and everything that can get across the finish line, because we've got an end with the Supreme Court. Obviously, we don't know what's going to happen with the final outcome, but I think the strategy might have been a little bit different if they had lost that case, but that's not the case. And that's, I think, how they're thinking and assuming what the thinking that goes into the strategy.
And in this case, the court in the Flores settlement, the court in California, Judge Dolly G, has to agree that these regulations incorporate the settlement and are sufficient to obviate the settlement or get rid of the settlement. And there's already several lawsuits going on claiming that the administration is not meeting its existing requirements under Flores. So this will automatically have to go to court. And so that's another reason why I'm sure the administration is thinking we might as well put something out there and see how far it goes.
A lot of advocates have said that this is a policy of indefinite detention. Is that how you see this?
It's indefinite in that there's not a maximum period of time. The administration has said they don't intend to hold people for, a long, long period of time, just until their cases can be decided. But that's the problem. Right now, cases can take a very long time. The administration has said that the average case time in detention for people who have cases pending is around 50 days, but that's a little bit misleading because many people, because they're in detention, may decide not to pursue their claims knowing that it would mean a longer period in detention. So those numbers are getting skewed. But on the other hand, that may be the actual intention of the administration. People in detention who abandon their claims are returned. That's fewer people they have to deal with. So there's lots of different things going on here. In general, the advocates are highly opposed to any sort of detention of any length of time for children. It has been shown medically that it's bad for children, but the administration really does need to figure out what to do with the families arriving at the border. It is true that migrant smuggler organizations and, frankly, the migrants themselves know and understand that coming as a family right now means pretty much that after a very short period of detention, they will be released in the United States. That is a factor in why we're seeing the numbers we're seeing. And so finding some way to address that in some humane way, but also have a fair adjudicated process is what's needed here. This is only one tiny piece of it. And without all those other pieces, it's not likely to be successful.
Right. I mean, the whole thing is whether you can carry out a coherent process for receiving, processing, and serving these populations. And if the only thing that you have is, the capacity to hold them for longer periods of time, but you don't have a process, and you don't have infrastructure to move them along through this process, you're just going to be compounding the problems that we already have. So this by itself, without any actual coherent framework, is just not going to address the problem.
All right, up next, public charge regulations. Earlier this month, the Trump administration unveiled the final version of what's called its public charge rule. Now, that rule, which the administration has been working on since late 2017, expands on a part of the Immigration and Nationality Act that prevents people from gaining a visa or green card if they might become dependent on certain public benefits. While the administration has promoted the rule as a necessary update to the immigration system, immigration advocates have claimed that the rule limits migration from poor countries in regions like Africa and Latin America and will scare non-citizens from accessing public benefits that they're entitled to. So what does the term public charge mean in immigration law, and how does this rule build on the existing framework for determining whether a non-citizen can travel or immigrate to the United States?
Well, the term public charge has been part of our immigration laws since pretty much some of the first immigration laws in the late 1800s. And we have to remember that at that time there wasn't very big public safety net. There wasn't things like food stamps and and cash assistance and Medicaid and all of those other things. But at the time, it really meant someone who did not have or appear to have the ability to work enough to sustain themselves and their family. So they would look for whether or not somebody was able-bodied. They would look for whether or not they had skills that could enable them to get a job and work. They would look to see if they had any money when they arrived, or they had family members receiving them who could support them. In general, over time, it has been used to a greater or lesser extent, mostly to a lesser extent, but it really was looking at whether or not people were likely to become majority dependent on the government. The latest update was after the Welfare Reform Act in 1996 that was signed by Bill Clinton, which for the first time expressly prohibited certain immigrants from getting benefits until they had had a green card for 5 years. It also created requirements for affirmative sponsorship, affidavits of sponsorship for family members, so that people knew that they had somebody to depend on. The Clinton administration tried to put regulations in place at the end of its administration. Those regulations were never final. So in the interim, from then till now, it's basically been the policy of the government to try to determine if somebody was going to be, for the most part, dependent on cash-based assistance and or institutionalized in the long run. It's very, very rarely been used to deny people entry to the United States on a green card or a temporary visa. This has been a priority of this administration to finalize these regulations and put a more substantive test, if you will, to this idea of who is likely to become a public charge for people applying for green cards and temporary visas to the United States.
The best way I would describe is, imagine you had a black and white photograph that's increasingly adding more color, and that this latest iteration is bringing in so many different frameworks for really assessing whether an individual is going to become a public charge, that there really is almost no comparison to what it initially, when it initially appeared in the immigration law. This is significantly more sophisticated, has a lot more dimensions, and I think that's what's really the key innovation with this policy.
Given the rule's broad scope, do we have any idea of the number of non-citizens it will impact in the future, and any sense of whether it will lead non-citizens to stop using public benefits?
Officially, we haven't seen any numbers from the U.S. government, but some immigration organizations have put out estimates. So the Migration Policy Institute, which I think has been doing a lot of work on this, they took data of recent individuals who got green cards, and they took a look at the tests that would be administered under this public charge rule. And what they found is that only 31% of individuals would not be affected by any of the tests and the different dimensions that you have to meet. 31% would not be affected by anything related to this rule. That's pretty significant. The other thing that they looked at also was how many individuals might disenroll from public benefits, either non-citizens who are eligible for certain benefits or individual non-citizens who live with U.S.-born children or other members, and they estimated that broadly 23 million individuals might make a decision to disenroll in some way, shape, or form. So it's going to be pretty extensive, and I think that's the thing about this test, is that the reverberations are so significant that in a way, it's really going to change the whole legal immigration system in the way that non-citizens and their U.S. citizen relatives access public benefits.
Yeah, I think a couple things is important to note. First of all, it's a test that we apply to anyone who's applying for a green card to come to or just to in the United States. It also, and the test that Chris is talking about is estimated the number of green card applications it would apply to. But it also can be applied to anyone who's trying to come on a temporary visa to the United States. This could be students, this could be workers. It theoretically could apply to visitors, but most visitors are coming for a short enough period of time that, it's not as onerous. So it would affect, an awful lot of those kind of folks as well. I'm thinking specifically about people coming on temporary work visas, like an H-2A or an H-2B visa, where they're in lesser skilled jobs. They're making the prevailing wage, but they're not making a lot of money, and whether or not this test might apply to them. Now, it's also worth understanding that non-immigrants in general are not eligible for any of these benefits at all. So applying this charge to a population that can't access them seems odd, but that's what the regulation says. The other thing to understand is that there's a large and extensive rubric for looking at different types of benefits that are applicable and who they apply to. And then, there are positive factors and negative factors and highly positive and highly negative factors, all of which is meant to make this look like a very objective test. But in the end of the day, the adjudicator has to weigh all those factors in something called a totality of the circumstances test and determine whether somebody is more likely than not to be a public charge, which is defined as 12 out of 36 months that you would use some form of assistance. So in the end of the day, it's still a rather subjective test, but it's very broadly applied. And so, as Chris said, we could see an awful lot of people finding themselves at the other end of this saying, I guess I don't meet that test.
I think the one thing to sort of wrap this up with is that Theresa last year, when she saw the version for notice and comment, noted that test kind of installs through a back way a merit-based immigration system. There's a lot of things that you look at and going, well, this is really similar to what you would do when you're assessing an individual for allowing them in a merit-based system, and I think that's really
it's a positive factor if you have high skills. It's a negative factor if you have low skills. It's a positive factor if you're of working age. It's a lower factor if you're above working age or under working age. Those are all the kinds of things that would go into a type of point system that the president has been talking about.
And I think that's the significant thing, that this is being done without legislation. And I think if it goes through and it's able to survive the litigation, that's incoming.
Yeah, that's the last thing. There's been at least a dozen states that have launched lawsuits against this now.
But, regardless, it's going to be pretty extensive, and it's going to be it's like I said, major change of the legal immigration system.
So it wouldn't be This Week in Immigration, finally, if we didn't talk about litigation. So what is the status of litigation against these rules?
Yeah. So the Flores settlement, as we mentioned earlier, does have to go back to the court that oversees the Flores settlement in California. Aside from that, there may be other lawsuits against it. The public charge rule, as I mentioned, there's been launched by several states. Also, some advocacy organizations are launching litigation.
Counties.
And counties saying that this will affect the citizens who are eligible for benefits at the state or county level who now are not come forward to get it, and that impacts the state and the county. We have to wait and see how those go. The fact of the matter is this administration now is pretty much used to, and even they said they fully expected it to be litigated. That shows a little bit in the drafting of the rule, particularly the public charge rule. Dara Lind over at ProPublica published an article that said that there seems to be some sloppy drafting in that some populations that you would expect to be covered are covered and others are not. So, for example, there's an exemption from the requirements for active duty military and their families, except the exemption applies more broadly if the military person is an immigrant themselves than if the military person is a U.S. citizen. That seems like it wasn't necessarily what was intended, but that's how it's drafted. So those kinds of things in a very large regulation that was hastily put together probably are going to be also fodder for litigation down the line.
All right, after the break, the border apprehension numbers. All right, finally, let's turn to the latest news about the arrival of migrants at the U.S. Mexico border. Earlier this month, U.S. Customs and Border Protection announced that the monthly Southwest border apprehension numbers dropped for the second month in a row, raising questions about the reasons that have led to this decline. The drop in apprehensions comes as the ongoing legal battle of the Trump administration's border enforcement policies and the treatment of migrants in detention continues in the courts. So, Theresa, what's the latest on regulations denying asylum to migrants who arrive at the U.S. Mexico border from a third country?
Sure. So I think when we talked about this last, the administration had proposed the rule. They were immediately sued. A court in California issued a nationwide injunction against it. That was appealed to the Ninth Circuit Court of Appeals. The Court of Appeals kept the injunction, but only for the region covered by the Ninth Circuit, which is California and Arizona. And it left the rest of the rule to go in place in New Mexico and Texas. So technically, as of right now, the provision of the regulation that says people who arrive and apply for asylum who have transited another country cannot be eligible for asylum in the United States would apply to anyone who arrived after the date of this ruling, August 16th, in New Mexico or Texas. But it would not apply to migrants in Arizona who arrive in Arizona or California.
And then advocates, I think, filed another emergency request to review this decision, and that hearing, I think, is being set, should be happening around the time that I think folks will be listening to this podcast. So it's not done.
Yes. So there's ruling appeal. It's not done yet. And, we have to see.
It's that same race to the Supreme Court.
It is. It really is. Advocates are hoping that they get a nationwide injunction in place so it can't go in place while it's waiting to get to the Supreme Court. Of course, the administration hopes it goes the other way like the MPP program did, where there wasn't a nationwide injunction and they could continue doing it until it gets to the Supreme Court. We've seen both rulings out of the Ninth Circuit now, so honestly, not clear which way this will go.
Basically, it's ping pong. It's immigration litigation ping pong. That's what we have right now.
Yeah.
That's one way of looking at it.
So we've also seen developments in 2 cases over the conditions facing migrants in federal custody, including the conditions for migrant children. Tell me a little bit more about those 2 cases.
Right. So one case was filed over the conditions of medical access to medical care, particularly in ICE facilities. This is a larger case that has to do with whether or not migrants who are in Immigration Customs Enforcement facilities, both family and single facilities, have adequate access to medical care. This was an issue that was raised in DHS Office of Inspector General reports as well as in other reports. And so that is one of the suits. The other lawsuit was over the standards that are happening in CBP custody. We talked a lot about the overcrowding and the fact that children were being held for longer. And there was an argument about whether or not certain requirements were certain humanitarian and hygiene requirements were necessary while in CBP custody. This was a notable case that made the news where a government attorney argued that things like soap and toothpaste were not necessary to have hygienic conditions in CBP custody. The judge ruled against them in that case and said, yes, indeed, you are required to provide these things. This is part of the Flores settlement as well. But there's other ongoing objections in that court case about ongoing conditions in migrant holding facilities along the border that are in mediation right now between the government and the plaintiffs in those cases. And of course, all of this will be relitigated with the Flores regulations that just came out.
Chris, what's your take on the latest apprehension numbers from the border?
So we've seen apprehension numbers now drop for the second month in a row. And the question is, why are they dropping? The numbers are still pretty high, especially for family apprehensions when you're looking at it from a historical perspective. But there's, I think, the 3 key takeaways is this. Mexico has increased its enforcement actions against the entry of migrants into its territory from Central America. This time of year, because it's very hot, tends to see lower levels of migration to the U.S. Mexico border. And they think, finally, what you're thinking is, well, are the smugglers kind of doing a wait-and-see approach to see what's going to be happening with these regulations and what's happening with Mexico's enforcement actions? Those are 3 things to consider. I think it's too soon, though, to really know what's driving it. Every time you see a drop in apprehension numbers, people try to focus on one thing, but I really do think that anytime you see broad changes, you really need to take into account the totality of circumstances. The one thing that I think is interesting to me is this. When you saw very high levels of monthly apprehensions around the year 2000 to 2005, what you saw is this, and unfortunately our listeners can't see this, but imagine you saw a huge spike and then the spike just dropped off significantly like a slope. And it did this for a couple years, huge spike, drop, huge spike, drop. And what was happening is that you saw just these large numbers of apprehensions and then it's dropping off. But that was driven primarily by single Mexican men. We're now starting to see that a little bit with these numbers, but it's driven by the arrivals of families from Central America. So this is interesting because you're seeing these same patterns repeat, but with different populations. And the question moving forward is this going to be sort of a new normal where you see huge spikes and a drop off, or is it going to sort of drop off to where it's been in more recent years, where it's kind of been more gentle waves, just a little bit of increase, a little bit of a decrease? And I think that that's really the key question moving forward. Are we going to see a repetition of historical patterns? Are we going to see a reversion to what we see more recently, or are we going to see something entirely new?
There's a couple other things that are worth noting. There was a lot of news made in 2017 and 2018 about the migrant caravans, and we really have not seen that phenomenon now for several months. That seems to have fallen off, and it's unclear the causes for that. There have been crackdowns by Mexico on migrant caravans, Guatemala as well. So that has probably impacted the numbers. What that means, though, is that most migrants are coming via smuggling organizations, and the smuggling organizations determine when they go, where they go, how they go. And again, they may be saying right now it's too hot. Let's wait and see what's happening, both temperature-wise and in terms of enforcement. When the Mexicans stop enforcing, which we expect they will do, then we'll try again. Or in the meantime, we're finding other routes. That could be one explanation. But the other thing is that we have seen, at least recently within the last week, another very large group by bus at a remote port of entry in New Mexico. There was another 250 migrant group that was encountered in Antelope Wells, that very tiny station in New Mexico that we heard about where there were buses coming through. That happened again last week. So I think, like Chris said, it's really too soon to make predictions that we're on the other end or this is going down. We have to see how the changes affect and whether there's any longevity to the actions that Mexicans are taking. But certainly ascribing any single cause to this is a little problematic at this point.
Well, there's so much more we could talk about, but I think that's a good place to leave it for this week. Theresa, Chris, thanks so much for joining me. And thanks to you all for listening. We'll be back in 2 weeks. In the meantime, please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_Bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. Just search Bipartisan Policy Center. This episode of This Week in Immigration was written by Chris Ramon and myself and produced by Yafat Tawahara. That's all for now. Join us again next time on This Week in Immigration.